Hi everyone, Attorney Rachel Kelley here, owner and managing attorney of Your Path Family Law, serving the metropolitan Kalamazoo, Lansing, and Detroit areas. Today's No Bullshit November tip is going to be about going to trial. So first of all, what does that mean? Well, if you have a initial divorce case or an initial custody case, meaning that you've never had a written court order reflecting what your agreement is with your child's other parent or with your spouse who you're hoping to become your ex-spouse, then your matter could end up going to trial. Trial is the last possible step in resolution of a divorce case. And what many lawyers might not say is that the vast majority of cases do not go to trial. I think the last stats on this showed that less than 2% of all new divorce filings in Michigan actually end up going to trial. And the reason for that is really because, frankly, trial is very expensive, and most of the time you are going to be better off reaching an agreement with your ex, even if you have to give up something substantial in order to get something you want and in order to have the certainty of the outcome. Because the reality is that if you go to trial, you're relying on a judge who doesn't really know you other than what they're allowed to hear about you through the divorce case, a judge who comes to that with their own biases, right? Judges are supposed to be neutral fact finders, but we can't erase who they are. At the end of the day, they're people. So if your judge is someone whose father wasn't really in their life and they always felt really sad about that, they might have some sort of bias that they're going to give up equal custody to a parent, and I'm just creating a hypothetical. There are so many potential things that a judge could come to an idea with as an unconscious bias they don't even realize that they have. So that's another reason why often we don't go to trial. But the third and kind of really important reason that a lot of times we encourage our clients not to go to trial if settlement is possible is because judges screw up. Yeah, judges screw up. In fact, in family court, judges screw up a lot because a lot of them were not family court experts before they became judges, and they're not required to do any specific training once they become judges until they go to judges school. And sometimes there can be years between an appointment on the bench and when they go to that judges school. And that's not to say that judges don't try. In my experience, all new judges try really hard, but the reality is that this is just a complicated area of law. And so if you are going to trial in front of a judge that was not a family lawyer, there is a strong likelihood that they could screw up. And if they screw up, then you may end up with an appeal. And now what you thought was a really expensive divorce because you've gone to trial becomes an even more expensive divorce because you're going back to court to go to the Court of Appeals. And if your judge did make a legal mistake, the Court of Appeals is going to send that back to them and say, hey, you screwed this up. You need to try again. And guess what? All of that is just costing you a lot more money. So ultimately, your goal should never be, I want to take this case to trial. Your goal should be, how do I work out a settlement that gets me as close to the outcomes that I want that I can live with? Your counsel should always be ready for trial if trial is the only option, but trial should always be your last resort. Hope this video has been helpful. If you have any other areas that you want me to talk about, we'll be here 3 times a week in November giving out these no bullshit tips.